Good afternoon. I'm John Pierce, Dean of the Faculty of Environment, and I want to welcome you to this inaugural lecture for the fall lecture series for the Faculty of Environment. And our speaker today is Paul Cassidy, and it's a great pleasure to welcome Paul, and we really appreciate the time and commitment to come to SFU. Let me give you just a very brief bio, a very impressive bio of Paul's. Paul is one of Canada's leading environmental lawyers and is a senior partner in the Vancouver office of the national law firm of Blakey, Cassels, and Graydon. As well as head of the Blake's Environmental Group in Vancouver, he has practiced environmental law on a full-time basis for 23 years. He's provided expert evidence on Canadian environmental law and legal proceedings in the U.S. and is the only environmental lawyer in British Columbia to be named in the list of leading 500 lawyers in Canada by Lexpert American Lawyer magazine. Paul's practice is a combination of regulatory, corporate commercial, litigation, and policy development work carried on for clients throughout North America in a variety of industries, including energy, natural resources, and the manufacturing sectors. He has an in-depth knowledge of the natural resource sector in Canada. He's governor of the BC Business Council, is the past co-chair of the Canadian Environmental Law Forum, and has served as a member of the board of directors of the Association for Mineral Exploration in British Columbia. He's also served on the board of directors of the Ontario Forestry Association and the board of directors of the Nature Conservancy of Canada in BC region. Paul is a frequent lecturer, not surprisingly, at universities and management courses on environmental law and management. And he has published several articles on environmental issues and was a founding editor of a book on forestry law in British Columbia. So please welcome Paul Cassidy.
Thank you. Thank you. Thank you very much, Dean Pierce, and I want to thank you and your colleagues for inviting me out here today, because it's an absolute pleasure to come to Simon Fraser and meet some very bright people and hopefully interested in the topic that I'm going to speak to today, which I was asked to address. And it's really an interesting topic to me. I hope you'll find it interesting. After 23 years of practicing environmental law, there's a tendency to get a little long in the tooth and think you've seen it all and heard it all and done it all, but in fact that's not the case in environmental law. It's a rapidly changing field. And that's why I want to address one particular topic to give you a sense of where I think environmental law, if any of you are interested in it or interested in its ramifications, where I think you will see it going increasingly, and it already is going in Canada today. And in fact, when I first started practicing law 26 years ago, I was a brand new lawyer and thought, well, what area am I going to practice in? And I decided to practice in criminal law. And then 3 years after that, I decided to leave the Crown Prosecutor's office where I was and go back into private practice and try my hand on the other side, from defending alleged criminals to perhaps representing alleged criminals or doing other types of work. And sure enough, about 3 months after I started private practice, an oil company had a very bad spill into Lake Erie, where I was at the time in Toronto, and I got a call at about 4 o'clock in the morning to go help the company face the consequences of a 365,000 gallon oil leak into Lake Erie. And as you can imagine, that was sort of that many years ago the equivalent of a Deepwater or an Exxon Valdez in the Ontario context. So I got a baptism by fire, but as you can see in that context, what I was dealing with was a very localized matter, a spill from an oil refinery in southern Ontario into Lake Erie. Unfortunately, it didn't get over to the American side of Lake Erie, so we weren't dealing with an American-Canadian international incident. But for several years after that, I was focused primarily on environmental law issues that were really locally based. That is, issues that only really dealt with, for the most part, provincial law. Even federal environmental law was not a big player. So I was dealing with typical issues involving spills like that, involving people buying and selling businesses locally and learning how to assist people buying and selling businesses in with regard to provincial environmental laws, who should be responsible for the mess left behind. I was working a lot with companies who were facing challenges in the way they were doing business, the mining industry and forest industry in particular, which perhaps explains why I'm wearing a suit, because you may think an environmental lawyer I was running around with sandals, but I tend to wear suits because most of my clients are on the business side, not all, but most. But it was all very localized. But then things started happening, and this is what Dean Pierce and Paul Kingsbury and I were chatting about at dinner one night, and Catherine Harold back there. We were talking about how actually it stopped being localized about 5 years ago. And now my practice, environmental law, and what I think is increasingly the overall scope of environmental law in Canada is actually much more internationally based and much more internationally impacted than it is locally. Sure, I still deal with a few spills. There happened to be one that occurred down the way here on Inlet Drive about 3 years ago with a pipeline break. That's a rather local incident. But a lot of what I do now is environmental law from an international perspective. And I think what it demonstrates to all of us in this room, or hope I will demonstrate to you, is that whether or not we like the global environment we're in, the global world we're in, we are in it. And environmental law is increasingly now governed by things beyond Canada. And the way that business actors behave is actually governed by laws and regulations, political developments far beyond our borders. And therefore, if you're going to practice environmental law, or if you're going to be even a student of environmental law, if you're going to be an observer of environmental law, you just can't focus on, for example, what the BC Ministry of Environment is doing or not doing, or what you think they should be doing, or what you think they should not be doing. In fact, if you want to be fully engaged as an environmental lawyer, my thesis now is that I've got to pay attention to many developments beyond our borders. So now what I'm going to do is show you some examples of that. And that is some typical scenarios that we get involved in, I get involved in, that I think hopefully you'll find interesting, that reflect on or illustrate this point. And I've actually got 4 examples I want to use, which will show you that now basically environmental law is an international practice. And the first one is a very interesting scenario that did develop about 5 years ago that I became aware of. And that is, I'm going to define each particular circumstance. This is where a company is doing business in Canada, but polluting elsewhere. So think about that for a minute. This is the first scenario that is going to be governed by international environmental law. You're doing business in Canada, presumably near a border, but not necessarily, but typically. And remember, 80%, I think, of Canada's population lives within a very small proximity to the border, certainly in comparison to our whole country. There's no question that most industrial activity in Canada tends to occur relatively close to the border with the United States. So you're doing business in Canada, but you end up causing pollution in the United States. You're not actually doing business in the United States, but things drift. It's called the drift factor. They drift by air, they drift by water, they may even drift by vehicle transportation. But the scenario that I'm talking about is really well illustrated in a case involving Tech Kaminko, a case called Tech and Pacudas. And this is where I first became aware of the significance of international environmental law to an everyday company. And I know you might say Tech is not an everyday company. They happen to be one of British Columbia's largest companies, certainly one of the largest mining companies in the world. But they have a smelter and trail that for several years in the first part of this century, slag from that smelter was going down the Columbia River and ending up in a man-made lake. Actually, it's a headwater for a dam, I believe, in Washington State called Roosevelt Lake. Mr. Pacudas, who is a member of the Colville tribe, who lived near Roosevelt Lake in Washington, started a lawsuit on behalf of his tribe against Tech on the basis that tech was failing to comply with an order issued against them to clean up, or at least come up with do a study to figure out ways to clean up the slag in Roosevelt Lake, which after all had drifted down the river from the Trail smelter to the lake in Washington State. Now, tech does not carry on business in the United States, but there had been an order issued, interestingly enough, by the second Bush administration, telling them they had to do this. And when they were not doing it, not doing the work or as required, the First Nations, or tribe as they're known in Washington State, sued tech. And tech then brought an application, and among a whole variety of applications, to have the order dismissed, have the lawsuit dismissed in the United States on the basis that no, we're a Canadian company. We don't even live in the United States. We don't even carry on business in the United States. You can't issue an order against us, reach into Canada, and tell us to do something in the United States, potentially clean up this mess in the United States, notwithstanding that there's no dispute that came from tech. Well, that is a very interesting scenario, because you have a company that does not actually carry on business in the United States, but is actually, in effect, being regulated in the United States. So now, here I am, this little environmental lawyer, I'm used to dealing with a little provincial ministry. All of a sudden now I got to figure out US law when I'm dealing with a client who may be subject to a US law, notwithstanding they don't even actually carry on business there. So it's not good enough for me as an environmental lawyer anymore just to know my little Canadian law. I got to understand or get liaising with an American lawyer. And of course, for those of you who may not know about the case, tech ultimately lost all its challenges to those orders in that lawsuit in the highest court in the United States Supreme Court. And next June, I believe, they're scheduled to go to trial on that whole matter as to whether or not they owe damages to the Colville tribe and whether or not they have to comply. Interestingly enough, tech did ultimately settle with the US government in terms of the order to clean it up, and they've agreed to do some studies and some work in that regard. But that really opened my eyes to the fact that, if you're thinking about environmental law and regulation on Canadian business, which I assume is one of the reasons why you're here to hear about this, you just can't focus on Canadian environmental laws, because there are a lot of businesses that carry on across the country, but who do this very same situation. That's not a unique situation to tech. For example, in Fort Frances, Ontario, which is in the northwestern part of Ontario, very close to the relatively close to the Manitoba-Ontario border, there's a pulp mill there that is actually on both sides of the border. I've been there. The actual border crossing runs right through the pulp mill. On both sides of the border. Now, where's the liability there? Where's the responsibility? Is the Canadian side responsible for the American side as well? Tech would argue, the resulting tech would argue that, well, yeah, I mean, just because you pollute to another border or across another border doesn't absolve you from the liability for that contamination. I suspect most of you in this room would agree with that. You shouldn't use an artificial border as a means to avoid liability. Nationalists, however, including the Canadian government, who argued against that extension of that liability, would argue that, no, we can't have Americans regulating our Canadian business. I'm not going to resolve that debate here today, but it'll be very interesting to hear your views on that when we get to a chat session later. So that was a very good example for me where my eyes were opened about, I know all about local laws. In fact, we even got a publication on environmental law and regulation of British Columbia, which I will give you. You're welcome to take a copy of. It's a summary of all the environmental laws in British Columbia, but this is really only part of the story of what we have to deal with when we're talking about the regulation of business and the environment today. Some more examples. And this scenario I'm now going to paint to you is called doing business in Canada but regulated elsewhere. The last one, tech, was doing business in Canada but polluting elsewhere. This one is called doing business in Canada but regulated elsewhere. Now, this is a very interesting scenario that I think you're going to, at least I find interesting, hopefully you will when we're done here, and that is you're finding now that business in Canada, if it wants to do business elsewhere, has to understand the regulations elsewhere, or else it's not even going to have a market to it. To market into. And I'll show you a very good example, renewable energy. In BC, you probably would have had to have been living under a rock if you didn't know that a major foundation of the current government's policy initiatives is the pursuit or promotion of renewable energy, clean power. Everything from the controversial Run and River hydro projects to wind power. You know, the Campbell government, along with virtually every other government in Canada, I might add, wants to promote a renewable energy industry. Well, it's of real resonance in British Columbia because we have this huge market south of us that is crying out for renewable energy, for green power. Anybody know what that is? California. California is the place you ought to be. Because the California state legislature about 7 years ago passed, for reasons not related to anything other than, in my view, the high price of oil and energy security, they passed a law that required that the utilities in California providing power to all their customers, that is their equivalent of BC Hydro, had to procure at least 20% of their energy sources from renewable energy. That is green energy, wind, solar, etc. That is non-fossil fuel burning. Then they realized, you know, you can pass all these laws all you want, but then they realized that they don't have any such capability in California to meet that demand. In other words, there aren't enough wind farms in California, and there isn't enough desert to build solar power panels on in California that could possibly reach that 20% of their demand. So 20% of all their demand had to come from renewable energy. They can't do it domestically. Where are they looking? Here. That is a tremendous economic opportunity for British Columbia, which we may or may not succeed in capitalizing on if we can ship our green electrons down to California to keep the lights on in Los Angeles. But there's a problem. That debate, or that legislation in California subsequently has been up for significant debate in the California state legislature, such that 2 weeks ago, a bill was debated in California to actually, there were several bills, but one was to increase that requirement from 20% to 33% by 2020. But at the same time, there's legislative proposals in California that says, no, we're going to put all this on hold pending the end of the recession. Believe it or not, there were assemblymen in California who said, no, we don't want to have that because it's too expensive to get from somewhere else, and we want to have the power generated here, even though all the studies suggest California can't do it. We want to have all the work done here and all the power generated here to create local jobs, and therefore, as a result, there's this bill out there that actually would stop the importation of renewable power from British Columbia. But look at what's happened here. That is, you are a renewable energy company in British Columbia. You have the development of a wind farm you want to produce up in wind generation up in, say, Fort St. John area. If you can get it down to California, you have this great market. In fact, there's more demand in California for renewable energy than anywhere else in the United States, and British Columbia is ideally suited for it. But what if the market dries up? What if, in fact, that proposition passes? What if, in fact, the legislature completely does away with the 20%? They don't go to 33%. So you see what I mean? You're carrying on business in Canada. You've got a wind farm, clearly a local business. It's a wind farm right on the ground near Fort St. John or near Chetwynd, Ontario, British Columbia. But you're at the mercy of a bunch of California state legislators and Arnold Schwarzenegger. Because if they don't have that market down there for you, or they somehow artificially impede it, it means you're not going to have a business in British Columbia. So what's really interesting is I now have to, advising these companies, I have to be right on top of what's going on in Sacramento. And believe me, you think British Columbia politics is interesting, you ought to see California politics and California regulations and the complications. And I don't profess at all to be a California lawyer. I often have to work with other lawyers in California to try and understand this because it's really foreign to me. I really have to get up to speed on it. But I have to spend more of my time doing that than I actually do flipping through my overview of, the Environmental Management Act or the Water Act of British Columbia. That's what really counts to those clients, is what is going on down there. Notwithstanding, they're never going to set foot in California other than their electrons. So that's another example of where international environmental law, and you might say, oh yeah, it's only American law, but we are separate countries, has a major, major role to play in how Canadian business conducts its affairs or whether it even has a business. But I want to move further afield outside North America and provide you with the next example, which is, the title for this one I have is called Doing Business Elsewhere. So the first two were doing business in Canada and polluting, doing business in Canada but regulated elsewhere. This one is doing business elsewhere and regulated elsewhere. So this is more of a traditional scenario. This is a scenario where a company, and I'll use the mining industry as the best example because we have a world-class mining industry in Canada that actually carries on business all over the world. That's why it's world-class. And a company is developing a project in Africa, South America, and they're regulated in those countries. So what's old is that they're doing business in these other countries. What's new is the environmental regulation. In other words, in several of these countries now, in the last 5 years, you are seeing a real growth in the impact of their environmental laws. Believe it or not, that is happening. And I can pick examples in Africa and I can pick examples in South America where the local environmental regulations are showing real teeth. So that you have a Canadian business with a mine in Guatemala who are now subject to as strict, if perhaps not stricter, environmental regulation in those countries domestically. So now I have to pay attention to what goes on in Guatemala because, as an example, in June of this year, Goldcorp, which is one of Canada's leading gold mining companies and based here in Vancouver, actually had a mine shut down in Guatemala by the Guatemalan president involving Goldcorp's Marlin mine, shut down because of concern about environmental impacts on the local population relating to emissions from the local mine. And you might say, well, so what, big deal. But you see, that was a domestic decision made by the Guatemalan government. And interestingly enough, however, there was a local NGO from British Columbia called Mining Watch who were actively involved, as I understand it, in lobbying the Guatemalan government to apply their own laws. I don't think you would be surprised to learn that 10, 15 years ago that probably wouldn't have happened. So you're now seeing a lot of local environmental laws in the operating jurisdictions, if you will, of Canadian companies starting to show teeth. And that's an interesting development that I've seen really in the last 5 years. So again, I'm starting to think I shouldn't have gone to a Canadian law school. I should have gone to a law school somewhere else because, Shelley here, my colleague, is a brand new lawyer. Tomorrow she'll be sworn in as a lawyer. And maybe I should just send you back to some law school in, Mexico, Shelley. You don't want to do that? No, you don't want to go back to law school? Okay. To learn all these. In fact, if I were going to law school now, I would definitely take a course in international environmental law. It used to be that in international environmental law was all about treaties, and it was all these, the Basel Convention or some convention on the handling of international transportation of hazardous waste. I mean, just yawner stuff. Or it was conventions that really were just treaties that really never took effect. And one might argue Kyoto might be an example of that. But now we're seeing these other things that are, the Bush administration issues an order against tech. What was that all about? Somebody must have had a brain freeze or something in the Bush administration at that time, but it had real effect. Do you see what I mean? So you have these various ways now in which environmental law really impacts, aside from what I call the rather esoteric treaties that we've had in the past. And just to digress a bit on that, you'll be interested to know that there's been a commission since the 1920s that exists in Canada called the International Joint Commission, the IJC, with the Americans, which was an international treaty commission or an international body, a joint American-Canadian body that was designed to deal with border disputes precisely of the tech nature. In other words, if one country was unhappy with the behavior of another country in respect of an environmental issue, they could complain to the International Joint Commission and have the International Joint Commission deal with it. And that commission was created because of an earlier problem with the Trail smelter back in the 20s. what was interesting about the tech case is they just completely ignored all that. I mean, the Bush administration, the US EPA office region in Seattle just issued an order under their domestic legislation saying clean this up. They didn't go to complain to the International Joint Commission. So, you know, I don't mean to denigrate all these international treaties, because I'm about to talk about one. But what I've illustrated to you is what I call the real international environmental law that impacts the way Canadian business operates domestically and internationally. So the final example I want to talk about of what I call real international environmental law is the scenario of doing business everywhere and regulated everywhere. So the first two examples were doing business in Canada. Then this third example was doing business elsewhere, like in, for example, one country, and I chose Guatemala as an example. Now I'm going to talk about doing business everywhere and regulated everywhere. And you're going to say, come on, Paul, I mean, you know, what is this? Is there an international law that applies everywhere? Well, there is, and it's coming to a neighborhood near you, and it's called climate change. It's called cap and trade. We're going to have this. I mean, in your lifetime, you almost all look younger than me. In fact, you're all younger than me. That's the safe thing to say. And I can tell you, we are going to have climate change legislation that is internationally binding. We are going to have climate change legislation or regulation like cap and trade that will be imposed one way or another on Canadian business. Now, this is going on tape, and I'm sure that you can look at this 20 years later and see if I, in fact, am right. I won't be here probably in 20 years the way my lifestyle is working, but I can tell you, I'm going to bet you a nice coffee, maybe a little bit more, we are going to have climate change regulation in Canada, and it will not be a Canadian context or a Canadian law. It will be an internationally based law. We have to. I mean, you know, let's face it, climate change is happening and we better get it or we're going all in big trouble. And so I now have to pay attention to what the US Senate is or is not doing, and I start learning about all these senators. You know, I mean, Senator Waxman and Senator Markey and Senator Biden, or now Vice President Biden, and hopeful at one time Senator Kerry. I mean, you have to start paying attention to what American senators are saying, because, of course, the Canadian government has said we're not prepared to move on climate change unless it's in concert with the Americans. Now, whether or not you agree with that, that is a reality. I mean, we cannot do a made in Canada solution to climate change. We can do it, but that's nice. It's going to get changed someday. The Americans are going to have climate change legislation. And I'm predicting, once again, a fearless prediction, you can check in 20 years, that the legislation is going to have hard caps. That is, you're not going to be able to produce more than X amount of carbon a year, you being all of us in this room and all of us collectively in Canadian business, and there's going to be a trading mechanism. And it's going to be at least a North American trading mechanism, if not an international one, because of course they're already doing that in Europe. There already is a trading mechanism. And I believe that is a classic example of regulated everywhere, and you're carrying business on everywhere, because it doesn't matter whether you're in Guatemala or whether you're in Canada. If you want to have a trading regime whereby if you don't use all your carbons, if you generate carbons less than your allotment or your allowance, you can trade that. Well, if you're carrying on business in Guatemala with a mine, and it actually is a very efficient mine and doesn't generate what it's allowed or permitted or up to its level for carbon, you can trade that because your mine in Colorado might in fact have excess carbon production. So there's going to be all sorts of offsets and allowances of an international nature. So that's a fearless prediction that I'm actually going to finish my presentation on, because I'm willing to bet some of you debate that, and some of you would have different views, and I, being a lawyer, love debate, and love to be told I'm crazy and all sorts of interesting other things. But I think what I've done is illustrate to you that if you're interested in environmental law, if you're interested in how we regulate our impact on the environment as human beings, which I think is essentially what environmental law is, the regulation of human impact on the natural environment, you have to think more than just your local scenario. I know the think globally, act locally, but if you just look at your own little NIMBY world or your own little provincial world, like I used to, you're lost, because most of the time you're missing the bigger picture or the bigger context. It was really driven home to me once when I was doing a hearing in Powell River about 4 or 5 years ago, and a local NIMBY organization was taking my client to gears. I represented a major industrial facility in Powell River, which you can probably figure out what that was, who were trying to develop a new technology for their facility, and a local NIMBY group was very concerned about the local impact on the air quality that this new technology would create for the residents of Powell River, and they blamed several of the recent bad weather incidents in Powell River on the local facility. And when I say bad weather incidents, I basically mean a lot of dust, particulate, were being blamed on the local smokestack industry. In fact, those incidents were the result of Chinese coal production drifting across the ocean to Powell River. The local citizenry could not accept that. They could not accept that their little community of Powell River was actually being impacted by Chinese coal production. How could it get from China to Powell River? So we had to call one of the world's leading experts to testify at this hearing, one of the world's leading air quality experts / meteorologists to testify. Oh yeah. And to me, that was just a dramatic example of, in fact, that we are all one big world, and that's another amazing insight into the obvious. But the reality is that it's not just a scientific connection that we have that, in fact, happens to us. We now have a jurisdictional connection, we now have a legal connection, we now have a political connection. So my takeaway message from this is, if you're interested in environmental law, think globally. So I've now run past my time, I think, and I'm certainly happy now to take questions, comments, criticisms. And I do want to thank you for being so attentive, and I'm appreciative of the opportunity once again to be here. Thank you.
Thank you. Well, obviously lots to think about here, and who would like to start off?
Thank you for your presentation. It's very interesting. I was wondering about a fifth circumstance you gave us for one where you're doing business elsewhere, but you're regulated here. Because there's a case I'm familiar with. I think it's ongoing right now. Ramirez versus Copper Mesa, which is a group of Ecuadorians trying to sue a copper company that had a mine down in Ecuador.
Yep.
Sue them and the TSX for selling shares in Copper Mesa for environmental pollution down there, and just whether there's any developments in the front of being able to hold Canadian companies responsible for their actions overseas here in Canada.
You know, that's a very good question, because I debated whether or not I would include this scenario, and it's the one area yet which still needs a lot of growth. In other words, it's a one area that really needs a lot more development. And I'm sorry, what your name is? Marina. Marina's question essentially says, look, you know, I'm operating a mine in Ecuador, or I'm Goldcorp operating a mine in Guatemala. You know, I'm allegedly causing environmental harm down there. Why can't the alleged victims sue in Canadian courts, for example, for that harm? And that has been tried. And it has met with mixed success around the world, and virtually no success in Canada. And I'm going to refer you, there's a very, very good paper written in 2008 by a professor at Oxford University. It's Professor John Ruggie, R-U-G-G-I-E, and it's called Obstacles to Justice and Redress for Victims of Corporate Human Rights Abuse. Obstacles to Justice and Redress for Victims of Corporate Human Rights Abuse. It's 3rd of November 2008. If you just Google John Ruggie, R-U-G-G-I-E, he wrote it for the UN, and he did this is a 376-page paper, a survey on just that, obstacles obstacles to justice and redress for victims. And the paper's real focus is Marina's scenario. That is, what is the current state of the law, and what is the opportunity for that to happen? And I'll say, for those who believe that should occur, that is, that you should be able to take legal action in Canada against, in this case, Canadian companies operating abroad, the law is not good if you wanted to commence that. I mean, if you're a Canadian company and you wanted to resist those, the law is great. A 2006 case involving a company called Cambior, C-A-M-B-I-O-R, they're a mining company. They had a bad tailings pond. You know what a tailings pond is in a mine? They had a tailings pond failure in Guyana, I believe, and the local victims there sued in Quebec to try and get redress against Cambior, and that in fact was dismissed. There was found to be no cause of action in Canada that would allow that. A lot of times it gets caught up in the legal principle called standing. That is, you don't have a legal right to sue in Canada. The United States, interestingly enough, has a couple of statutes which oddly enough, were designed to get around that problem. Usually the United States doesn't let anybody sue anybody in their jurisdiction, but they have two statutes, the Torture Victims Protection Act and the Alien Torts Statute, or ACT, I believe it's called, or ATS. American, you know, the use of alien is always an interesting phrase in the United States, but those statutes, one of which is very old, and one of which was just in the 2000s, are designed in part to get around some of those issues that allow people to sue locally for incidents abroad. I decided not to raise that because, quite frankly, it's not really big on the Canadian radar, but your question nevertheless is a good one, because you should watch for that if you're interested in that. Just last Friday, Chevron was successful in winning a lawsuit in the United States, though, because some Nigerian victims of an environmental issue in Nigeria, alleging that Chevron had caused them harm from an offshore drilling well, off Nigeria. Chevron won a lawsuit against those victims who claimed that they could sue in the United States, and the very high-level court in the United States said you can only sue individuals, you can't sue corporations in the United States, which is ugly, because most of these activities are carried on in corporate vehicles. But anyway, that's a long-winded answer to an excellent question. I hope that's been helpful.
Hi, enjoyed reading your talk. Apparently you're not an academic because you finished with enough time for us to ask some questions. That's great. You said in your opening remarks that you noticed about 5 years ago this change, and I'm wondering if what you attribute the change to. Is it something that has been sort of just general globalization building up, or would you attribute it to free trade or a particular legislative vehicle?
It might be something as simple as my own inattentiveness to something that had been going on for a while. That again is a very good question. I think it's in fact the result, in many respects, I would argue, it's the result of the internationalization of knowledge. The internet has just made this so much easier for information to be communicated between parties, between governments, between individuals, between organizations. There's just so much more connectedness. And in fairness, it probably did start about 10 years ago, but I think you've got this much more worldly view that regulators have. You have much more worldly view that NGOs have. The Guatemalan example was, as I said, was a major spur of that, was an NGO in Canada pursuing the Guatemalan government, and they just have so much more ability now to work together. So an academic paper could actually be written on this topic, is what is it that spurred this? And again, you accurately point out I'm no academic. I'd leave that to the good people, the Faculty of Environment, to research, because I think that the reasons for this are probably more significant than me just saying the internet's expanded. But I have to tell you that I've seen it exponentially occur. I mean, I've been in this area for a fair number of years, and it's really taken off. And I don't think there's any one particular political event. It's not like 5 years ago we had a deep water that caused everybody to pay attention. It didn't happen after Exxon Valdez. I mean, I've been around long enough to remember that. It didn't happen with other major international incidents. It's almost occurred exponentially, but very quickly in the last 5 years.
Paul?
Oh, here comes an academic. Now I'm in big trouble.
Thanks, Paul. I think I've got 3 questions.
Okay.
The first one pertains to the first example. So I was particularly struck that you mentioned it was a tribe, First Nation in Washington.
Yes.
So I wondered whether the status of not being entirely subsumed by the nation state in the ways that First Nations are regarding their territories or a tribe, whether that was a key factor in that transnational litigation. Second point, the construction of the sawmill, right, on the US-Manitoba border.
Yes. Yeah.
Wouldn't that have been kind of formalized when it's constructed, the building and so on?
You mean the pulp mill in Fort Frances?
Yeah, I mean, I bet it's a complete spaghetti,
Yes.
the whole law thing. And
Yeah.
I guess the third point, if you have time, was what are your thoughts on the future regarding international law, particularly in North America, where it seems to me Canada has tremendous natural resources, and in North America, especially large urban centres like LA, there's greater, there's going to be lots of stress on looking for resources.
Yeah.
Wouldn't it be the case then that Canada is sort of has a strong position to maintain regarding resource litigation or environmental law in general for the future?
Yeah. Okay, I'll try and deal with those if I can in the order. The subsuming issue with regard to First Nations is a good one in that particular context, because the Colville tribe was actually the real live party in that. The Bush administration issued that order, and then it was almost as if it was an oops. I mean, what did we do? And there was a certain reluctance to go further. And I'm only an observer in this. I wasn't involved, but it appears to me there was a certain reluctance after howls of outrage were voiced in Washington. And it was the Colville tribe that actually pushed that litigation and pushed the saying, look, there's an order out there, you have to do this. And the state of Washington then jumped in as an intervener on the side of the state of the Colville tribe. And I think that the unique position that American tribes have in the American law, in large part, was a big factor in allowing them to do that.
Right.
I don't purport to be an American native rights lawyer or a native law lawyer, but as it was explained to me, it certainly appeared that they were there as an equal, if not the most important player in that piece, aside from Tech, obviously, who are obviously a very important player in it. It will be interesting to see what ultimately turns out in that particular matter. I have to tell you a bit of an anecdote on that with regard to the matter that went to the U.S. Supreme Court. Tech asked for permission to have the order overturned, asked the U.S. Supreme Court to get involved, and they refused. You know, there was a lot of commentary on whether or not the U.S. Supreme Court would get involved, and they decided not to. They just said, no, we're not going to get involved. You guys have to go deal with that. So as important as an international law matter it was, the U.S. Supreme Court decided we were not going to get involved. So they obviously didn't think it was that important. With regard to the the pulp mill that I referenced in Fort Frances, Ontario, this is a good example. That pulp mill was built in the early part of the last century. I mean, the pulp mill has been around forever, and there just was no concern about, where the border essentially was. I mean, it is very odd to be on a pulp mill facility and walk across a private bridge that crosses international border, which I've done. And as soon as I heard about the Tech case, I thought, what are they going to do in Fort Frances? And that's just one example. I mean, Calais, Maine, and St. Stephen, New Brunswick share the same fire department. All right, and that's just one example. I'm sure we can find others around the country. And there are all sorts of municipal. I mean, I think there's one municipality which has its waste treated in the other country. And so, where does the line for liability fall now? And the problem was that all this infrastructure was developed without any real regard to where the liabilities are going to arise. And I forget your other question.
The future of resource control.
Oh, yeah.
It seems Canada. I know the
Yeah.
usual scenario is the Americans would dictate the terms.
Yeah.
But with Canada, it really has a lot of resources: uranium, water, and
Yeah.
timber.
The geopolitical context there is fascinating, and I don't pretend to be a political scientist or a political prognosticator or what's going to happen, but there's no doubt, I think, that the Canadian resource base provides us with a tremendous opportunity to exercise influence in North American politics that we wouldn't have had otherwise. The question, of course, is whether or not we want to exercise that, whether or not we have the will to exercise it, whether or not we should. Those are, again, our debates for, I suspect, in this facility here to have, and then ultimately in Parliament. But on the other hand, you shouldn't just necessarily assume because we have all the resources that we can dictate. Remember, there's 10 times our population down there, and the renewable energy situation is a good example. I mean, we have all the resources, but for renewable energy, we have far more renewable energy resources than any country other than Russia. Oddly enough, I mean, if you look at our wind potential alone, we have the second highest amount of wind energy potential in the world outside Russia. If you look at our solar, believe it or not, we have some. If you look at our run-of-river, we have far more. Run-of-river, do you know what that is? Small hydro. We have so much resource potential here, but that doesn't necessarily mean that we can go down to Sacramento and say, this is what your law is going to be. So, you know, it depends on a variety of other factors than just having that resource.
I'm Lee McGregor. I'm the manager of recruitment for the faculty. So thank you very much for your talk, and congratulations, Shelley. And because you love it, you're crazy. So I meet up with a lot of potential environment students at the secondary schools, and many of them want to be doctors, lawyers, and, well, pretty much nothing else. What do I tell the prospective lawyer? What should they study at the undergraduate level? What would make them the best environmental lawyer? What has Shelley got that you brought her into your firm?
Shelley's got a lot of overall talent, and you know, I don't want her ego to run away with her since she hasn't even started practicing law yet. There's lots of time for that to happen with lawyers, but it's really an overall, and you know, I'm not fond of the word holistic, but it's really an overall perspective that you need to bring to practice environmental law. And what I mean by that is, don't fall into the trap of taking nothing but what you think are environmental law helpful courses, like, you know, don't think that just because you have a degree in biology that you're going to be a good environmental lawyer. Don't think because you have a degree in fisheries or a degree in chemistry, or don't think that, you know, you're an engineer and then you want to become a lawyer, an environmental lawyer, that's really going to be helpful. There's no question that that will give you a leg up in many respects. I actually have an undergraduate degree in, you know, something boring like political science, history, and a mishmash of other liberal arts courses. And perhaps I'm biased because of that, but because everything I've just talked to you about now is so policy oriented, everything I've talked to you about is, you know, really the science is almost secondary. I mean, we make decisions on environmental issues that in fact are completely divorced from the science. And I'll use a good example. Section 36.3 of the Fisheries Act, the single most powerful piece of environmental legislation in Canada by far, is Section 36.3 of the Fisheries Act. If you read no other environmental law at all in Canada, go to Section 36.3, subsection 3 of the Fisheries Act, and read the statement that says that it is an offense to deposit a deleterious substance into waters frequented by fish, for which you will pay a $300,000 fine. And then when you realize that a deleterious substance is defined without regard to concentration or receiving environment, you realize how powerful that legislation is, such that if Catherine Harold drops a glass of apple juice into the Fraser River, she's committed an offense under Section 36.3 of the Fisheries Act, completely divorced from scientific reality. Scientific reality would suggest that any deposition of a chemical has to take into account duration, exposure, concentration, and receiving environment. Any scientist will tell you that. The Fisheries Act doesn't care. So why should I care if you have a science background? It doesn't matter. What matters is that you have, I believe, an overall perspective, which I think, hopefully I'll find out if Shelley does, because she's just started practicing for me. But I think you have to have an overall perspective. I think it helps to have a policy background. In fairness, it helps to have a science background. I mean, I had to learn what BOD meant and VOCs and all this on the fly. And, you know, to cram that into my history major mind was tough. So yeah, it might be helpful to have a course in basic biology. Might be helpful to have a course in, you know, fluid mechanics. You pick your undergraduate course, but please don't focus on, you know, all of that. I want you to have a broader perspective as much as possible. And you know, one of my colleagues has an undergraduate degree in music. One of my colleagues has an undergraduate degree in urban planning, which is invaluable because she probably would laugh at me for making the position that it's an international practice, because as a degree in urban planning, she really drills down on, you know, what's happening in Surrey and how can we help this development either succeed or fail or whatever. She's really focused on municipal environmental issues. And I don't mean to denigrate her practice at all. I mean, she works very closely with me and she's very capable. She works on a lot of the other projects, but I would encourage you to take a course on, international relations, by way of example. So those are some of the broader themes that I would encourage you to take. Is that helpful?
Yes, thank you very much.
Yeah.
I'll steal all of that and regurgitate it.
Go ahead, Ken.
Time for one more quick question.
Mm-hmm.
Paul, I want to ask you about your feelings. I know you'll be very comfortable with this. I'm wondering if, for perhaps the more idealistic mind, if you feel that you can be an environmental lawyer, if you feel for yourself as an environmental lawyer that you are working in the defense of future generations, or if it's so often just the reality that it's in defense of perhaps shorter-term corporate gain?
These are all great questions. It's probably a combination of both, but I think you have to take a long-term perspective on it. I'll show you a good example. Working on a project where a company is working with a local municipality to develop in concert with the local municipality. They're developing a facility that will service their industrial needs, and at the same time, they're developing a water treatment facility for the municipality. It's a very remote municipality somewhere in Canada, I will say. And the municipality, of course, will be governed by very strict health regulations. The industrial facility, because it's not engaged in a public service, has to meet industrial standards. The infrastructure will be common. In other words, the infrastructure for the industrial facility and the infrastructure for the municipality's facility will be one and the same. And that's why it's the industrial facility is actually going to do the project for the municipality. And it will eventually be sold to the municipality. Who knows? It probably will be. But that's a long-term situation. That's probably 25 years down the road that the municipality might be able to afford it. What do? You could actually build the industrial facility and service the municipal facility based on industrial standards. Much cheaper. But in fact, long term, it's going to be, the plan is, but nothing's guaranteed, it's going to be turned over to the municipality. So you have to basically say, look, let's plan long term here. Let's actually incur the cost of a higher grade facility that can be turned over to the municipality, because eventually, you know, the long range thinking is it's going to be there. And you might well have somebody say, well, why would I do that? You know, I'm just doing this as a favor to the municipality because they are broke, they can't afford it. And I'm just doing this because I'm going to be in and out of that community in 5 years. So what do I advise them, right? Legally, all they have to do is build it to the industrial standard. They don't have to build it to the municipal standard. They could say, if you guys want to come back and do an upgrade in 15 years or 20 years, if you think you can afford this thing, then you do it, right? So as an environmental lawyer, I'm sitting there saying, yeah, legally, it's probably a good idea, legally, financially, to just build it to the industrial standard. But if I were you, if I were in your position, this is what I would say, and what's what I do say, I'd build it to the higher standard. And then they're going to say, well, why would you do that? You're just costing us more money. And I said, let's think long term here, okay? Let's think long term. If you build it to the higher standard, and this is where you appeal to everybody's sense of community and self-worth at the same time, and self-interest, you would say, look, I think we should in fact build it to the higher standard because in 15 or 20 years you may want to turn it over to the community. That is what everybody's thinking in the back of their mind anyway. And you're going to avoid liability because you're going to build it to the highest possible standard. You're going to reduce your liability, rather. You're going to say, we built it, we overbuilt this facility. So there, you're appealing to self-interest and you're appealing to long-term interest in what I argue is the appropriate approach. So when I'm involved in these processes, you know, I think it pays to think long-term. And it pays to think of a broader perspective. And it's very convenient in that case because I think legally it actually saves and reduces their long-term exposure. Because obviously if they build it to the lower standard and something fails, someone's going to say, why didn't you build it to the higher standard? Well, just because you say we're not required to, you know, who's to say some judge is going to really like that in 20 years? Is that helpful? Just a little anecdote.
Any more questions? You mean we got through this without any mention of tar sands?
I do want to just say one thing. I've left extra copies of this overview of BC law. My American clients love this because when they do business in British Columbia, they like to come up and understand the local laws because they understand they have to. And this is just a summary of, and Shelley was involved, were you involved in this or was your predecessor? Your predecessor, yeah. We all sit down and say in relatively clear terms what each individual environmental law in British Columbia is about. So you just heard me rave about the Fisheries Act. There's a little more raving in here you can read if you're interested. Sorry, I just want to get that in.
No, thank you. Just two observations. First of all, thank you very much for an extremely insightful lecture today. And I was thinking when Mark Roseland was asking his question about how did this all arise, and I was thinking about Michael Ignatieff's book, what is it called, The Rights Revolution, something to that effect. And you know, I think there is there's an ethical change taking place in a global sense, and I wouldn't be surprised if that's at the heart of this, in combination, of course, with the internet and access to that and the spread of information. The other thing that comes to mind, Paul, is the issue of externalities, and you didn't use that term, but that's essentially what we have been talking about, and the long arm of regulation and the if you like, the shadow of regulation getting longer and longer with respect to externalities, and externalities really have no borders any
That's
longer.
right.
And I think the examples that you've given us today clearly point that out. And, so I want to thank you for that, and I hope at some point in the not too distant future you'll come back and we can continue this discussion.
Well, I'm happy to. Thank you very much.
Very
Thank you.
much.
Thank you.